Now, the topic of today's video is how does one take title, or what we call hold title, to real property? And remember, title means ownership in real estate. So how does one take ownership in real estate? All right, so let's get started here. The first thing I want to do is give you the 50,000 foot view. And we've already talked about a lot of this in previous videos, but I want to do a recap. So there's this term called a freehold estate. Now, a freehold estate simply means ownership. Somebody has ownership in a piece of real property. Now, a freehold estate is broken down into two areas. All right, the first one's what we call fee simple, or sometimes called fee simple absolute. And the second one is called a life estate. Now, I did a previous video on life estates, what they are and what you need to know for your licensing exam. If you would like to view that, go ahead and upper right-hand corner of your screen, there's a little I. Click on that. That's a link to the life estate video. All right, the other one is fee simple. Now, fee simple means absolute ownership. All right, and this is broken into two areas as well. There's severalty. Now, severalty simply means single ownership. Hope I put sign up there. I meant single. S-I-N-G-L-E, single ownership. The other one is what we call a concurrent estate. Concurrent estate. Now, there are three subcategories of concurrent estates that you need to know. This is where we get into how we take title to real property. The first one is called joint tenancy. The other one is called tenants in common. And then we have community property. Now, community property is not available in all 50 states. So there is a chance that you may live in a state where community property is not recognized. So let's talk about the basics of all three, and then we're going to run through an exercise and it'll kind of help you illustrate what I'm talking about here. So joint tenancy, the first one. Now, joint tenancy is typically reserved for, not reserved, I should say, it's typically implemented by married couples because it does offer some protections for the joint tenant. Now, one requirement is there has to be 2 or more people to qualify. All right, 2 or more people. There is no willing of interest, no bequeathment. No bequeathment. The other part is corporations, no corporations, S corporations, and those type of things. So one of the joint tenants cannot be a corporation. And the reason is under the law legally, a corporation never dies. All right? The other one, it's what we call with rights of survivorship. And this means that when a husband and wife own a property, for example, in joint tenancy with rights of survivorship, and the husband dies, the husband's legal interest or ownership in the property automatically reverts to the surviving tenant, which in this case is the wife. And we're going to talk more about that in a minute. All right? Now, there's 4 key things also that you have to understand. This is very important for the real estate licensing exam. All right? Title, time, interest, and can you think of the last one? Title, time, interest, and possession. And what we mean by that is unity. So that means the married couple, the husband and wife, they have had to have taken title, title, possession, time, and interest at the same time. And think about this, it makes sense. So if a husband and wife or a married couple, it doesn't have to be a husband and wife. That's just the most common. It could be 2 brothers or a family of 4 or whatever. However, but here's what happens. Think about it. So a husband and wife, they buy a piece of property and they go to closing. And they sign all the documents at the closing table. They have acquired title, possession, time, and interest in unity, all at the same time. One of the things that I get a question about all the time is you have a single person. Let's say that Tom purchases a property, and he's a single person. He owns or holds title to that piece of property in severalty. But what happens if he gets married 5 years down the road? Well, they can't use or they can't claim joint tenancy with rights of survivorship because they don't have unity in these 4 items. You have to know these for the real estate licensing exam. All right, that's joint tenancy. The other one is what we call tenants in common. Now, just like joint tenancy, you have to have 2 or more persons. All right, 2 or more people. There will be undivided interest. Undivided interest. Under joint tenancy, the interest has to be equal, 50-50 for 2 people, or if there's 3 people, 1/3, 1/3, 1/3. There cannot be an undivided interest with joint tenancy. With tenants in common, we can have undivided interest. One person can own 80%, the other one can own 20%. All right, you can have corporations. And you can bequeath. You can bequeath your interest as a tenant in common to one of your heirs or your estate. All right, very important here. 2 or more people, undivided interest, corporations can be an owner, and bequeathment is there. And then the last one is what we call community property. Now, community property is reserved only for married couples, and what it basically says is it's protecting the spouse of the deceased person. But it's only reserved for married people, and it's reserved to the assets that were accumulated during the time of marriage. So maybe you have a second marriage, and the husband and the wife, they have basically accumulated assets because previous marriages and whatnot. Then they get married. Well, during that time of marriage, anything that was acquired by that married couple during the time of marriage belongs to the surviving spouse. However, all the assets that were accumulated before marriage will be willed off or given off to heirs or be part of the estate. So community property is only there for married couples. All right, so let's run through some fun scenarios to kind of illustrate what we mean here. Okay, let's say there is a house at 123 Main Street, and there are two parties that purchase this, and they purchase it with rights of survivorship, so joint tenancy. Now remember, with joint tenancy, rights of survivor, whoever the surviving person is gets the interest of the other. So in this case, we got Tom and we got Sally. All right, so notice that it's 50-50 ownership. Remember, one of the requirements under joint tenancy is equal ownership. There has to be an equal interest. Now, if Tom dies, then Tom's 50% reverts to Sally, who now owns 100% interest. And when we have 100% and it's one person, we call that severalty. All right, so that's the first scenario. So let's add a joint tenant. So let's say that there's Tom, there's Sally, and then there's Sarah. So we have Tom, Sally, and Sarah. Now they pitched in their money to buy this house at 123 Main Street, and it's joint tenancy with rights of survivorship. Okay? So that means that they all own 1/3 or 33%. That is their ownership interest. And again, I'm going to keep beating this dead horse. If it's joint tenancy, you cannot have an undivided ownership interest, and they have to be equal. All right, so Tom decides that he doesn't like Sarah, he doesn't like the living arrangement, so Tom sells the property to Tim. Now, one of the things you have to know about joint tenancy is any one of the joint tenants can sell their interest off. All right, so in this case, Tom sells to Tim. Now, Tim owns 1/3, Sally owns 1/3, and Sarah owns 1/3, but the relationship has changed. Sally and Sarah still have joint tenancy. All right, they still have joint tenancy. But Tom is tenants in common. So the relationship between Sally and Sarah and Tim is tenants in common. So if Tim dies, he can will his portion off to his heirs. However, joint tenancy still exists between Sally and Sarah. So let's say that Sarah dies. Well, then her interest reverts over to Sally, who now owns 2/3, and Tim owns 1/3, and the relationship now is called tenants in common. All right, so that is a scenario that you might have. So let's run one more here. All right, I wanted to run through one more scenario here just to make sure that you understand how this works here. So we have 123 Main Street that was bought by Tim, Sarah, Sally, and Bob. And remember the 4 elements of joint tenancy with rights of survivorship. A unity in time, title, possession, and interest. All right, so they have 1/4 interest or 25% interest in 123 Main Street. Now Tim dies. Tim's 1/4% will revert equally to the 3 remaining joint tenants. So now Sarah owns 1/3, Sally owns 1/3, and Bob owns 1/3. All right, so Sarah dies. Her 1/3 reverts to the remaining joint tenants. So Sally now owns 1/2 and Bob owns 1/2. Joint tenancy still exists. So then Sally dies and her half reverts to the remaining joint tenant Bob. So Bob now owns 100%, and when you own 100% by yourself, that is called severalty ownership. That's how this progression would work. So